Yes, yes.
So isasubmit dito sa mga taong hindi ninyo kilala samantalang kayo ang nagpa-imprenta? Senator Bato, please.
Madam Chair, gusto ko lang ipa-confirm kay Mr. Unyate. Sinabi niya kanina na he sought the help of the speaker para makakuha ng perma. So, pumayag siya. In fact, nag-meeting kayo, di ba?
Yes, yes.
Pumayag siya. So, meaning, sinabi mo, perma ang nasa likuran nitong People's Initiative. Humingi kayo ng suporta galing kay Speaker Romualdez. Binigyan kayo ng tulong, ng suporta para tumakbo yung People's Initiative. Ibig sabihin, si Speaker Romualdez isa na rin sa nasa likod ng
Pumayag naman po si Speaker.
Pumayag
si Speaker.
Nasa likuran na rin siya.
Natulungan kami kasi siya ang CEO ng Congress.
Kaya nga, gusto ko lang confirm sa'yo na siya rin ay kasama na, nasa likod na rin ang papatakbo ng PI. Dahil nga, tumulong siya sa inyo, di ba?
Yeah, he is helping us.
Thank you. Thank you for that. Thank you for that answer. Madam Chair.
Maraming salamat. So kinukumpirma mo, parang nagugulan ako, kinukumpirma na politicians initiative, tulad ng sinabi ni Senator
Hindi naman po. Tumutulong lang sila. Pero kami ang nasa forefront ng pagpapapirma. Palagay ko, wala namang masama na tumanggap ng tulong sa mga congressmen.
Senator JB raising his eye. Sige, tama naman. Patulong kayo sa lahat ng tao, lalong-lalo na yung mga CEO ng malalaking kapulungan. Senator JD, please.
Thank you, Madam Chair. Curious ako, pwede tanongin si Mr. Oñate or the conveners of itong PI. Of all the provisions that can be amended under the Constitution, bakit napili ng pirma i-amendahan yung provision on the manner of voting? Di ba? Kasi pagkakaalam ko, na kung meron kayong gustong amendahan sa Constitution, dapat ang tatanungin, either political or economic provisions, pero yung voting provisions or manner of voting, nakalagay doon, voting jointly. Bakit po yun? Talagang gusto ko na pong maliwanagan.
As one of the petitioner, Mr. Chair, Senator Ejercito, we specifically propose amendment to the manner of voting because this is the consistent roadblock that prevents Senate and the House to propose amendment to the Constitution. When I was the chair of the Committee on Constitutional Amendments, we passed the RBH 2. Pinasa namin sa House of Representatives, 19th Congress. We transmitted the RBH 2 to the Senate.
Iba kung People's Initiative, pwede naman diretso sa economic provisions.
Tama po, and that's why
economic na kagad.
Yes po.
Bakit hindi economic ang
You cannot put one subject in a petition. That's Republic Act 6735, of which you cannot put more than one subject in a petition. And that's why to erase that roadblock, which is a consistent roadblock in proposing this amendment to the Constitution, might as well that infirmity or ambiguity in the interpretation on how Congress will vote sitting as Constituent Assembly dapat ho maklarify. And that's why ito po yung pinakarason. Kasi kung ilalagay po natin yung Article 12, 14, and 16 of the 1987 Constitution, which speaks of the restrictive economic provisions of the Constitution, that would be inviolative of Republic Act 6735 that prescribe
Madam Chair.
that there should be no more than one subject in a petition.
Madam Chair.
Alam rin namin yon ang ating...
Yes, Madam Chair. Let us go back to the subject matter.
Boses,
Because,
I just put on record because being the chair of the Committee on Rules, only RBH 6 of the House calling for a constitutional convention was actually transmitted by Congress to the Senate. The RBH 2 has not been transmitted. That's for the record.
Madam Chair, you might forget, the majority leader might forget that in the 18th Congress, June of 2021, and you were still a member of that
Are we going to
Congress.
talk about other congresses or even the history of Congress? In fact, Madam Chair, I was about to make mention about the statements made by Mr. Oñate. If this is indeed a people's initiative and not a political initiative, bakit nanggagaling lahat sa politiko? Bakit sila yung nagtatarget sino yung mag-i-initiate? Hindi ho ba klaro na ito ay politician's initiative? Just to point it out, Madam Chair.
Baka naman siguro, Madam Chair, as you recognize me already, baka lang ang Senado sa mga agenda ng ibang politiko. Di ba? Ganun lang naman yun eh.
Here.
With due respect, Madam Chair, the point of order I see is that let's go back to the germane. What's germane to this topic, which is the signature buying, manipulation being done.
Thank you
is it
very
being
much.
through people's initiative or politicians' initiative? Let's go back to that. We will have our hearings on this issue on charter change where we
Yeah.
invite our distinguished friends, former congressmen and congressmen to those hearings, together with the justices, together with ex-justices, deans, and constitutionalists to debate on that issue. But at this point in time, let's go back to the main point of this hearing, which is we're trying to look for shenanigans, in the part of collecting these signatures.
Maraming salamat. Yes, and thank you very much for SP for establishing order. And indeed, it's a massive feat to conduct a project PI requiring massive funds. And you said that you largely, Mr. Oñate, funded PIRMA, at least with the EDSA Puera commercial. And you also admitted that it was upwards of 55 million that you spent. Do you have the receipt?
I think so.
So,
We have a receipt.
is it your office or your corporation or PIRMAS and NGO that paid for the ad?
Yeah, because I gave the money in cash to Mr. Greg Garcia, and he was the one that paid the advertising agency.
I'm a little bit confused. I was informed but that in fact payment was made to Gana Atienza Abisado Law Office. Why was it necessary to go through the law office? Did you need an escrow or trust account?
I gave the cash to.
If I may,
Mr.
Madam Chair.
Oñate, can you allow
I
Mr.
gave the
Oñate to
cash-
finish his sentence?
I gave the cash to Greg Garcia, who is our PR, and I think Mr. Greg Garcia was the one that paid the ad agency. I don't know whether it was forced to somebody else, but what?
So in fact, it
I
was
just
cash,
gave the money
there
to
was
Greg-
no
to Greg
receipt,
Garcia.
there was no BIR, no donor's tax, no documentation, it was cold hard cash, is that correct?
Yeah, it is. It was. I gave it to him in cold cash because, well, that's how.
I'm sorry, that's how politics operates, through cash?
Yeah, because I've also been a political consultant all these years, and I know how it works.
55 kilos of cash, sir. Hindi, ang sabi kasi binayaran through the law office. Nagugulan ako because you said you handed over 55 million in cash to Mr. Greg Garcia, isang bulto. Paano pumasok yung ating mga abogado?
Madam Chair, if I may.
Yes, Attorney Abisado.
To explain our role in the TV ad. What happened was this was very early start of the year, and when Mr. Noel Oñate engaged the firm of Mr. Greg Garcia for the creative agency, Mr. Garcia.
Nagugulan ako. At in the beginning of this year?
Yes po.
Nag-umpisa to December pa eh.
Yes po, on the creative aspect po, last year pa. And then, payment should be made for the TV stations ASAP. But since PIRMA could not comply, marami ho kasing documentary requirements. So what we did, kami na as the law office, since we can comply with all the documentary requirements ng pag-post nitong TV ads, kami na po ang nag-submit.
Paano yung cash? Ano yan
yung
ito sa
payment
cash?
po, when we were sent the bill, we gave it to Mr. Onyate. Ang sabi namin, sir, ito na ho yung billing ng ad agency. Kayo na ho bahala magbayad. That's what happened po.
Ipinapakilala sa iyo ang pinakamainit na dekalidad na damit na panloob ng lalaki mula sa Japan.
Face lang.
Ma'am, wala pa pong OR pero meron ho yatang invoice. May invoice ho kami to the law office kasi kami yung lumalabas na advertiser having complied with all the documentary requirements.
So, ibibigay ninyo sa amin yung OR, walang resibo at sekreto sa BIR kasi wala rin donor stocks.
Yes. Ma'am, wala pa po kaming OR but we have a billing invoice that we can submit.
Sige, titignan namin. So, ano nangyari dun sa cash? Akala ko, ang nagkaliwaan, yung cash ni Mr. Onyate dun kay Mr. Garcia. Paano pumasok yung law office? Di ko pa rin maintindihan eh.
Kami lang po nag-represent kay Mr. Onyate in the...
Bakit kailangan ng representation? May dala-dalang bultong cash.
That's a separate matter po.
Ha? Mas marami pa kaysa sa 55 million?
Di ma'am, when we told Madam Chair, Mr. Onyate, sir, ito ho yung bill. Kayo na kung bahala magbayad. And he said, sige, ako nang bahala. And then yung invoice ho, sa amin ho pinadala. And we will comply. We will submit the invoice sent to our office pero wala pa pong official receipt. And the amount that Mr. Onyate paid, kasama na po lahat yon, both the creative aspect of the ad and the TV placements for the 3 TV stations, ABS-CBN and GMA7. Yun po. Thank you.
Pero ikaw ang nagsabi, baka po bang donor? Pagkat ikaw yung nagpa-interview at sinabi nyo, ambag-ambag, tulong-tulong, attorney abisado, di ba sinabi mo yon na puro donation sa iba't ibang volunteer?
Yes, ma'am, I remember I told that. Yun din ho yung ni Mr. Onyate. And that is consistent with what he said earlier, that he paid the bulk of the TV ads, sarili niya pong pera. And the others, meron din ho yatang ambag-ambag.
Abogado ba kayo ng firma o member, lead convener din?
Ma'am, hindi po. We are lawyers of Mr. Onyate. He has been our client many years before. And in fact, he is related by affinity to our managing partner, Attorney Aris Gana. Magkamag-anak po sila. So that explains the connection between our firm and Mr. Onyate.
What explains the connection of your firm to Speaker Romualdez? Andito po ang liwaliwanag ng Congress dito sa posting na ikaw ay isang consultant ng Office of the Speaker. Itong retratong to nasa labas ng Speaker's office.
Ma'am, Madam Chair, hindi po ako consultant. You can check all the records. I'm not a consultant. But I don't deny, I know the speaker. He is
Di ba
a
tumulong
fraternity
ka sa
brother
Tingog?
of the
Di ba tumulong ka sa
fraternity
Tingog
brother
Party
of
List?
Upsilon. And kami po, we go a long way. But ang client po namin dito, hindi po si speaker, kundi si Mr. Noel Onyate. That picture, hindi ho ako, that was one of those times na sumama ho kami, tumingin, pumunta lang ho doon sa Congress. Kasama ho kasi yung isang associate ho namin na nandito. Pero ma'am,
Pero, so mali si Congressman JJ. Kasi anong liwanag o consultant to the Office of the Speaker.
yes po, with all due respect to the good congressman, hindi po ako consultant ni speaker and the record will bear me out. What happened?
Di ba naging abogado ka rin ng Tingog?
Nag-refer po ako ni speaker sa mga kamag-anak kay Mayor Alfred Romualdez who's been my client, and if you will admit, I am very proud to being one of your lawyers, Madam Chair.
Kaya nga alam ko na, ang pagkaalam ko, consultant ka eh. Kaya nagtataka
Hindi po. I wish I'm a consultant. Dagdag rin po yun, pero hindi po ako consultant. Wala.
Please,
Thank you,
anybody
Madam
would
Chair.
like to...
On the topic lang,
Yes po.
bakit po nahirapan ang pirma for the documentary requirements? In 1990, organization pa po ang pirma eh. So, what's wrong with their documents?
Very good question, Senator Pimentel. Hindi ko kasi updated yung payments. In fact, to be honest, updated yung records nila. In fact, ngayon ho kami palang nag-update ng records kasi ho, yung mga stalwarts ng pirma, sino Mr. Pedrosa and the other kasama ni Mr. Oñate, wala na po ngayon. So, kailangan ho namin mag-comply, kami na lang ho nag-step in.
Hindi qualified ang papers ng pirma. Para pagdating na nito sa COMELEC, even yung juridical existence ng pirma out na rin po kasi even TV stations will not air an ad because of the questionable papers of pirma. So how much more amend the constitution through pirma? I mean, that's just just an opinion na kung ganyan na sa TV ads lang hindi na pasado papeles ng pirma, and then you will see we are the group behind this, then we will file a petition sa COMELEC.
That is well noted, Mr. Good Senator. In fact, we agree with your sentiments. We respect your sentiments. Kami po sa pirma, for the record, we are against any form of vote buying, bribery, or aid in exchange for signatures because alam mo namin, napakahigpit po ng COMELEC. They will invalidate all the signatures given a very slight evidence of bribery. So, sayang naman ho ang pinaghinapan ng mga volunteers ho at yung coordinators ng pirma. Maingat din ho kami, sir.
When did you start soliciting signatures?
This year po, ang umpisa ho namin, Senator, is the information campaign which was started by that
The signatures. Ito mga form na with signatures. December pa to umiikot na eh.
Yes po, when we discussed, kami sa pirma this year po, pero yung grupo ni na Attorney Garbin, wala ho kasi kaming monopoly on People's Initiative. Marami din ho kasing gumalaw. So maybe Attorney Garbin can also speak for his group.
Pirma can tell this committee January.
Public information started with the with the TV ads, and then after that nag-gather na ho kami. Nauna si Attorney Garbin.
Pirma muna, pirma. Can you give me a date? When did you start soliciting signatures as pirma? Just a date. January 2, 2024. Si Attorney Garbin would be the Attorney Abad signature sheets.
Yeah.
December pa po yan, tama?
No, on our part,
First batch.
ako, concerned lang po ako sa Bicol region. Nag-start
Yes,
po kami January 5, including the distribution of the forms, the signature sheet.
So yung mga Mindanao, hindi nyo na, wala na kayo.
Wala na po. Bicol region lang po ako.
Pero
Senator Coco, natanggap ko yung timeline at yung form, December 23.
yes, December to sa Mindanao, ayan ang feedback na ano sa akin. Pero, so who will be the knowledgeable person to ask sa grupo po ninyo about the national movement?
Yung movement po namin ay maraming convener.
Okay.
But for every region, may assigned. Ako po yung assigned
Sa Region 5,
sa
okay.
Region 5, and I called 4 governors and the Liga ng mga barangays to facilitate.
If the community is interested to know the movements sa Mindanao, who do we ask in your group?
Wala ho po akong alam.
Sino bang nakataas sa iyo? Regional coordinator of Bicol Region. Sino pang nakataas? Because yun ang pupunta.
Kami ho yung nag-uusap. Kami nila Attorney Abad, kasama si Noel Oñate, Justice Piloso, former congressman, and Argel Kapatbat. Opo.
Okay, so lumalabas, Madam Chair, there may actually be 2 signature sheets na umiikot. Ibang wording nun. So, kailangan conscious din po tayo ron. And once this is...
Just to add minority
Once
leader.
let me finish, Attorney Garbin. Once this is formally to be presented, dadaan po sa microscope yung mga kada salita doon sa signature sheets na to kasi magkaiba pala, hindi dalawang grupo. And is it possible that there is also a third group, more than 2 groups?
There are numerous groups
Okay,
for this national movement.
kanya-kanya sila sa signature campaign.
Tama po.
Okay, so ganun pala. So it's not talagang i-examinin po lahat ito. Kanya-kanyang approach din sila.
And just to add minority leader,
Madam
if
Chair.
I may finish.
Madam Chair, Attorney Garbin wants to be
Yes, that when we greet each signatory, we tell them that petitioner din po sila. Hindi lang po si Attorney Abad, hindi lang po ako. Lahat na nag-gather naming signature, pinapaintindi namin sa kanila that they will be, part of this and be one of the petitioners of the People's Initiative.
Okay, notarized ba yung kada signature sheet?
Hindi po. But,
So, paano bagsak na kagad sa verified petition yun?
but as you see the signature sheet,
No, I'm just reacting, Madam Chair, to the inputs of Attorney Garbin. If all the signatories are to be treated as petitioners, bagsak na required. May we ask the COMELEC, doon po sa 10650 na sinuspend nyo, ang petition ba to be filed on People's Initiative must be a verified petition.
Yes,
So we go back to the definition of what is a verification. All petitioners. So the signature sheets and the signatories are treated as petitioners, but these are not under oath. I think the theory already falls flat on its face.
Mrs. Chair, Madam Chair, let me respond.
No,
The signatures will be
Sorry,
part
you
of
are
the
not
petition.
recognized.
Madam Chair, follow-up question to
Yes,
Attorney
Senator Risa has precedence.
Yamanak, Madam Chair. Attorney Garbin, sabi nyo, inassign po kayo sa Bicol. Sino po nag-assign sa inyo?
Ang aking
Sino
sarili po. Ang
Sino
aking
po
sarili.
nagkukumpas
Ako
kung
po.
sino ang ma-assign
Ako po,
sa
as I have said, I've
region?
been the chairman of the Committee on Constitutional Amendments. This has been my advocacy since the 18th Congress. Naipasa natin sa House of Representatives, na i-transmit natin dito sa Senado, the 18th Congress. And my exasperation, Senator Intuberos, was that it was not acted upon by this body. And therefore, ang nakita ko, ito na yung solusyon. Ako rin, gagalaw na rin ako upang ikayatin yung ating taong bayan na sumama dito sa isang makabuluhang pagbabago
At
sa
kaya
ating
gumagalaw, Attorney Garbin and Madam Chair, ang Senado dahil sa tingin namin may mga tamang paraan at may mga maling paraan. Sa ibang mga relihiyon po, sino nag-assign kung sino in charge sa bawat relihiyon?
Wala po akong alam kung sino nag-assign sa ibang region. But as you mentioned about tamang pamamaraan na
Okay.
Senator
No, it's all right,
Antiveros.
Attorney Garbin. No, it's okay po.
Even po
I don't
to
put
put
an answer to that. That was not a question, Madam Chair. So lastly po, inassign nyo ang sarili nyo. Kinukumpas nyo sarili nyo.
Well, I have, encouraged some of the governors to help me. The Liga of Municipalities of the Philippines, Albay chapter, spearheaded the movement in Albay, and we were able to get at least 15% of the registered voters in the 3 districts of Albay. So
So we'll have to hear from the
doon sa tatlong distrito, siguro minimum 15% yung aming nakuha.
At sa ibang rehiyon po, ay
Ay-
kanyang pag-assign din sa sarili.
Siguro po, yung may mga movement din doon na pinapangunahan ng ibang organisasyon, yun din po yung nangyayari kaya sa buong
So,
bansa.
siguro Madam Chair, dun sa bubusisi ng minority leader sa bawat isinumuting pirma, ay pwede ring itanong yung ano yung naging role ng regional leader, lalo na kung nag-self-assign sila. Madam Chair. Reminds me visions of Napoleon taking the crown from the hand of the Pope and crowning himself. So, but we can go into that later, Madam Chair, to verify.
akin
Yaman na,
kasi,
Madam Chair.
thank you very much, Senator Risa, and I'm in full agreement with the minority. I'm completely perplexed by this text, which I myself also received since I maintain my old congressional numbers. At ito yung natanggap ko na may alok na pagkaliwa-liwanag, 5 million DSWD, 10 million MAIP sa DOH, at 5 million sa DOLE Cash for Work Tupad. At ang mga pumirma ay napakaliwanag, inanyayahan rin namin, mga empleyado, yung INC yan, mga chief of staff yata ng kongresista to, Randy Londres, Attorney Ray Trahe, Kirby Bragais, Ana Jimenez, Annie Rose Mercado. Ang sabi sa akin ng ating committee secretary, hindi daw dumalo, kaya siguro kung maaari, isapina na po natin para magkaliwanagan ba't nagkaganon. At kung bakit yung mga pera na isanamtabi at binigay na natin para sa mahihirap, emergency and crisis situations, biglang ipamumudmod sa mga pumipirma. Anong klase yun? Kaya't eto nga, eto yung message na talagang kinalat ng maigi at kailangan alamin natin kung ano ang mga pangyayaring yan. So pagdating na lang siguro nila, siyasatin natin itong mga bagay-bagay tungkol sa napakalaking alok ng 20 million sa kada isang kongresista. Okay, andito ang liwanag, name of congressman, ilagay yung district at saka yung partido, nakakaintriga. At yun siguro. Nandito po yung COMELEC, kanina pa nag-iintay. Kung okay lang sa inyo, tuloy na tayo kay Chairman George Garcia at yung iba't iba pa. Na narito, ang pagkalam ko si Senator Francis Tolentino ang interesado magtanong, andito ang lahat ng COMELEC commissioners natin, puwera lang kay Commissioner Perolino. Pero lahat kompleto. Maraming salamat. Yes,
Madam Chair.
I think Senator
Go ahead,
Francis
Madam Chair, because I thought you wanted to talk about the COMELEC.
We're already beginning with the testimony of COMELEC.
Thank you, Madam Chair. Wala po akong tatanungin sa ibang mga resource persons. Rather than, I'll focus sa COMELEC. Yesterday, an en banc resolution came out. May we know, may this committee be clarified as to the current operative legal framework that we have now?
Madam Chair, Your Honors, magandang hapon po. As far as the COMELEC is concerned, as of this time, our resolution 10650, the one that we are using for purposes of the People's Initiative, is suspended. And therefore, as far as we are concerned, our local COMELEC election officers will not accept anything from anybody submitting any document concerning any signatures. At the same time, lahat po ng aspeto ng proseso ng People's Initiative are likewise suspended as of this time.
With the sufferance of Senator Tolentino, may I simply recognize our legal luminaries. We are honored by the presence of Justice Adolfo S. Ascuna, who may interject at any point. Our good Justice Tony Carpio, the Dean of La Salle, Jose Manuel Chel Jokno. I think Attorney Romy Macalintal is also here. And I invite you to interject and participate in this discussion at any point. Thank you.
Madam
Yes,
Chair,
Senator.
may we clarify from the good chairman what is the meaning of this interpretation of suspend? You suspend the effects, you suspend the implementation, suspend the acceptance of signatures. Ano po yung eksaktong para maintindihan ng mga kababayan natin?
Suspend, all in all, suspend the acceptance, suspend the implementation, suspend the execution, suspend anything in relation to the People's Initiative, because that is the law. That is the rule that we are observing. We honestly believe, Your Honors, Madam Chair, that COMELEC Resolution 10650 in its present form and content is insufficient.
Thank you, Mr. Chairman. Yesterday, we also heard from Total News reports that you intend to reframe, rehash, correct the existing resolution 10650. Ano po yung gagawin? Mapaguhin o i-amend? You found loopholes? Ano po yung gagawin doon?
Marami sabi, kasama na rin po, Madam Chair, Your Honors, yung enhance. Kasi po, Madam Chair, yung mga pinag-uusapan po kanina pa dito sa committee, katulad po ng mga issue ng paggamit ng pondo, halimbawa. Sa Section 16 po ng COMELEC Resolution 10650, nakalagay po doon, bawal ang paggamit ng public fund for purposes of signature campaign. Pero yung pong provision na yan ng COMELEC Resolution 10650, hanggang doon lang po. Wala pong nakalagay doon sa issue ng, are we going to remove the names? What will happen to the names of these people who perhaps have received something from anybody? Wala po sa rules yun. So, ibig sabihin po, pagdating, kung sakali po magkakaroon ng isang formal petitions commission na elections na hanggang ngayon po ay wala pa, magkakaproblema po kami, Madam Chair, Your Honors. Yung mga local COMELEC namin will insist just by looking na lang po sa signatures and determining whether they are voters. They may not even accept any objection to each and every signature because it's lacking in our rules. Isa pa lang po yun sa mga instances, Madam Chair, Your Honors, nang magiging problema later on kung sakaling we will allow this entire process to proceed.
And may we know from the good chairman how long will this curative process last? Ganun katagal yung gagawin to?
We're hoping, Madam Chair, Your Honors, that nobody or not even a single group will be pressuring the COMELEC to immediately come up with a guideline. Alam niyo po, Madam Chair, yung pong kaso ng Lambino versus COMELEC, 2006 po yun. The ponente of which was Justice Carpio. It took the COMELEC 14 years to draft COMELEC Resolution 10650. So kung 14 years nga po yun na-draft so sana po huwag kaming ipilit na mag-draft kaagad ng guideline.
Kaya ko po tinatulong to, Mr. Chairman, is that we're not discussing here we're not questioning the constitutional authority of the Commission on Elections to craft its own rules. But kung babalikan natin, Santiago case, operative order is inadequate. Republic Act 6735 is inadequate. Kung babalikan po natin yung Lambino case, Lambino never overruled or modified Santiago case. And yet, the Commission on Elections came out with its own resolution akin to an IRR, which, as far as my interpretation is concerned, which provided some curative measures insofar as the inadequacy of previous COMELEC resolutions. Sa tingin niyo po ba, Chairman, mas mainam na gumawa na lang ng batas ang Kongreso to amend Republic Act 6735, which the Supreme Court termed as inadequate, and also in that decision, the Supreme Court stated that COMELEC should be permanently enjoined from entertaining or taking cognizance of any petition for initiative and amendments to the Constitution. Baguhin muna namin yung batas bago kayo gumawa ng COMELEC resolution, o ituloy niyo po yung paggawa ng COMELEC resolution, amyendahan niyo yung resolution 10650 circa 2020. Ano po yung the respected magistrates can jump in? Ano po yung mas mainam na gawin dito? Baguhin mo namin yung Congress should amend 6735 or COMELEC should amend resolution 10650? At para mas matibay po, para once and for all, kung ano yung pagkukulang na nakita sa Santiago case na hindi naman na-tackle doon sa Lambino case, although meron 10 obiter doon, ano po yung mas mainam sa tingin niyo po, Mr. Chairman?
Madam Chair, since ang COMELEC po under the Constitution, under Article 9C, Section 2, is just there to enforce and administer election, we will highly respect whatever is the wisdom of Congress in this matter. Although we have our own opinion as regards Republic Act 6735 po, when it comes to whether it is sufficient or not. Hindi po kasi kami pwede magsalita hanggang ngayon sapagkat that will be the basis of any future resolution of the Commission in the event that a formal petition will be filed in the COMELEC. Kasama po yun sa sufficiency in form and substance, Madam Chair, Your Honors. And so it's premature at this point for the COMELEC to jump in and make a statement as regards the sufficiency or insufficiency of Republic Act 6735.
Oh, Mr. Chairman, wala po kayong rekomendasyon sa committee ito na baguhin na lang po na para sigurado na tayo kasi may provisions po ako na encounter yung sa initiative. There is such a thing as direct initiative and indirect initiative. So hindi pa mas magandang klaruhin na lang ng panibagong batas ito para once and for all, the law will set the appropriate standards on how COMELEC should issue the appropriate resolution. Wala na tayong gulo. Kasi akit na naman po ito sa Supreme Court. Sasabihin na Supreme Court, mawalang galang na si Justice Ascuna, professor ko po ito. Akit na naman sa Supreme Court. Sasabihin na naman sa Supreme Court, sinabi ko na sa inyo na ganito ito. Hindi na tayo matatapos dito.
Maganda pong suggestion talaga po kung magkakaroon ng pagbabago sa batas para maklarify na ang lahat. It should not be the COMELEC that should be clarifying anything. Our IRR should not be there to correct whatever mistakes, if there are, doon sa batas. Hindi po yun ang role ng implementing rules and regulation. Ang dapat po
What's happening right now, Mr. Chairman, is that the COMELEC will be correcting its previous IRR. And the previous IRR was made to supplant some loopholes found in RA 6735. So baguhin na lang natin 6735, tapos issue ng, or perhaps the Congress can make a very tight law na hindi na kailangan ng IRR. Kaya ko po sinasabi to, Madam Chair, napakarami na pong pangyayari na yung IRR, iniba yung batas. Meron po akong encounter doon na wala na dito yung mga Department of Health, yung
Senator
Near Code of the Philippines, binago nila.
Balik mo.
So, follow up lang ako
Yes.
sa sinabi ninyo. Okay lang. For all our legal luminaries, the justices who are here, perhaps you can help us. Perhaps the reason why COMELEC resolution 10650 is so defective is because the law nga that is trying to implement it, RA 6735, is insufficient to cover the PI as conceived in the constitutional amendment. Could this be the case? Because in the decision of Lambino versus Comelec, I believe the ponente being here, the Supreme Court categorically declined to revisit the Santiago ruling. Assuming for a moment that no motions for reconsideration were filed in Lambino, would you agree, Chairman Garcia, that the Santiago ruling remains valid? Because you have given interviews stating the contrary.
Madam Chair, Your Honors, this is a personal opinion as a former Dean of the College of Law and a former law professor. It will not bind the entire commission because this is being asked of me. With the kind indulgence of everybody, if we are going to read the case of Santiago versus Comelec, indeed, the voting was 8-6 in favor of insufficiency. However, Madam Chair, Your Honors, if you are going to read the motion for reconsideration, there was a sudden turnaround. It was a 6-6 voting, Madam Chair, Your Honors. In that 6-6 voting, Justice Hermosissima reversed himself and sided with the 5 who voted to declare 6735 as sufficient. And Justice Vitug refused to resolve Republic Act 6735 on its insufficiency of sufficient. One justice inhibited himself and the other justice said it's premature. That's why the voting after the motion for reconsideration.
But Chairman, the reality is, in its resolution of November 21, 2006, the Supreme Court dismissed all the MRs. Even if there was a sentence in that resolution saying that 10 members reiterated their position as shown by their various opinions, the decision is upheld as sufficient and adequate to amend through a people's initiative. Are you saying that this single sentence reverses the Santiago ruling?
Madam Chair.
Yes, let him answer, please.
Madam Chair, Your Honor, a reading of the dissenting opinion of Justice Pangaliban, of Justice Renato Puno would reveal that what was mentioned in the decision as to be having an injunction, a permanent injunction, is the Delphine petition. It is never intended by the court to be a prohibition in future cases for purposes of the determination of the applicability.
Yes, I don't think that's the question we're asking. It's very clear from the statement that the separate opinions of the 10 justices already mentioned had promulgated their opinions as early as October, before the MRs in November. Upon the resolution of the MR, the 10 justices merely reiterated what they had already said. So if the separate opinions of October 25, Lambino Ponencia, were not enough to overturn Santiago, how can the mere reiteration of these same opinions in November 21 suddenly overturn the entire Santiago doctrine?
Madam Chair.
Yes.
If I may, Madam Chair, just to add to the response of the good chairman to the chair's question, maybe the chair could also ask Justice Carpio to weigh in on this question.
Yes,
Yeah,
I was
Madam
going to
Chair.
allow Chairman Garcia, and then after that, of course, the very enlightened and personal knowledge of Justice Carpio. Yes, Chairman Garcia.
Thank you very much, Madam Chair, Your Honors. As far as because we are talking now of the Lambino versus Comelec decision, indeed, there was never, the Supreme Court said that they are not at liberty at that time to depart from the ruling in the case of Santiago versus Comelec. But however, again, it's subject to interpretation in the motion for reconsideration. There was this one paragraph which says that 10 justices of the Supreme Court are of the opinion that Republic Act 6735 is sufficient.
With the permission of the good chairperson. But as still have the floor. As at this point, Senator Trentino. But as lawyers to Chairman Garcia, again, you're expressing your personal opinion and not in any way binding the commission. It is clearly obiter because it was not needed to dispose of the case. The case was already disposed of. That statement had nothing to do with the disposition of the case on the merits. Now, I will not bind you to an answer, but a lawyer can interpret that too, in that manner. That although that statement was made in the minute resolution of Lambino, that is obiter insofar as the main case which the court disposed of already, as Senator Marcos said, all of the cases and petitions were dismissed. It would be fair to interpret it that way as well. Would that be a fair statement?
Coming from a very respected legal luminary such as the Honorable Senator, we will definitely respect such a position. But of course, that will be the subject of a future litigation again in the Supreme Court. That's why, again, perhaps it's the best time that this legal issue be resolved with finality by the Honorable Supreme Court.
Thank you, Madam Chair. With the indulgence of Senator Trentino.
Thank you very much, Senator Tolentino. Would you like to invite Justice Carpio at this point?
Justice Carpio can join us.
Yes, Madam Chair, Your Honors. If you look at the main decision in Lambino, you have to look at the dispositive portion. The dispositive portion, which is the binding portion, says the petitions are dismissed. And then in the motion for recon, it's the resolution of the court says the MR is denied with finality. So there is no reversal of Santiago because you have to look at the dispositive portion. That is the portion that binds everybody. So the statement in the MR that 10 justices maintain their position is just a statement of what these 10 justices said, which was already ruled in the main decision. So the dispositive portion should prevail. And there is nothing in the dispositive portion that reverses Santiago. Thank you.
Thank you very much for the very simple and truly enlightening clarification, Justice Carpio. I know that you had a previous engagement and you made a real effort to join us, so thank you for your participation. It's been most enlightening and clarifies that in fact Lambino does not repeal or change the Santiago ruling. Thank you. Senator Tolentino.
Further questions, Madam Chair, perhaps the next step for this Congress to do is amend Republic Act 6735 and then the Commission on Elections to issue appropriate resolutions to implement the amended law. Unless Justice Ascuna would want to say something. Wala na po akong itatanong, Madam Chair.
Maraming salamat, Senator Tol, and we'd like to call on Justice Ascuna's wait patiently from early this morning if Senator Cheese will allow the justices to please first take the floor.
Thank you, Madam Chair. In connection with the Lambino versus Comelec, I was one of the justices who voted in that case. I was one of those who, one of the 10, whose opinion was that Republic Act 6735 was sufficient to support an initiative to amend the Constitution. But the ruling was that there was no need to examine whether or not the Santiago ruling should be reviewed, because in that Lambino case, it was very clear that the proposal was a revision, and therefore it cannot be done by initiative. So the ruling was petition denied because it's one for revision. In the motion for reconsideration,
it is true that there's the last paragraph that says that the 10 justices maintain their position that the law, Republic Act 6735, is sufficient. However, I believe that, although I was one of the 10, I believe that that is not a binding statement. It merely reiterated our obiter dictum, our academic opinion, but is not part of the ruling because, as the main decision said, it is not necessary to go into that. That is what Justice Holmes called economy of jurisprudence. You decide only what has to be decided. You reserve for future cases what needs to be decided so that it will not bind future Supreme Court. That is economy of jurisprudence. So I respect that. Furthermore, Madam Chair, if we had reversed our position and reverse Santiago, the dispositive portion would have partly granted the petition, not denied completely. It would have said, wherefore the petition is partly granted to the extent that Santiago versus Comelec is reversed. But the petition is denied because it is for revision. But we didn't do that. We denied the petition completely. So that means we did not go into the review of Santiago versus Comelec. The same with the motion for reconsideration. It was, the dispositive portion said, all the motions for reconsiderations are hereby denied. Otherwise, it would have said, partly granted by reversing Santiago versus Comelec. We did not. So as Justice Carpio said, it's the dispositive portion that counts. And the dispositive portion in the Lambino case very clearly did not reverse or even touch upon Santiago versus Comelec. And therefore, I believe it still stands. Moreover, Madam Chair, the deficiencies pointed out by Chief Justice Davide in Republic Act 6735 in the Santiago versus Comelec case, that it is insufficient, inadequate, and incomplete. Why? Because it does not state what the petition should contain, whereas it states what the petition to make an ordinary law should contain. It does not state what a petition to amend the Constitution should state. Moreover, it says that the change shall be effective upon publication in the official gazette. Whereas in the case of an amendment of the Constitution, it is effective upon the plebiscite, approval in a plebiscite. So it is incomplete. There's no provision on the effectivity of the change. There's no provision on the content of the petition. Now, can the COMELEC supply that deficiency? I respectfully submit, Madam Chair, that the COMELEC cannot supply that deficiency. There has to be a law. Why? Because the Constitution says that Congress shall pass a law to implement this initiative. That's in Article 17. Congress is the one mandated to pass the law. And there is a principle in constitutional law called potestas delegata delegare non potest. Where the Constitution has put the power, it shall remain there. It cannot be transferred elsewhere. And so therefore, the COMELEC cannot